The most ill-advised claim since Oscar Wilde put pen to writ. At some stage I'll have to do a video about the trials of Oscar Wilde because they're really interesting. But this one is yet more Vardy and Rooney, because on the back of my last video a lot of you asked some very interesting questions which I will now seek to address. The first thing to note is that although we've had a 3-day hearing, and I mentioned that this is what we call detailed assessment, where they do a line-by-line analysis of every single cost as to whether they are in fact recoverable by the other side. This was just a preliminary argument. This was just preliminary issues. The actual detailed line-by-line assessment is now scheduled to take place early in 2025, although with a little bit of a hint from the judge that why don't you just all go away and sort this out among yourselves? You've been throwing far too much money at it. But yeah, what were some of the general principles? When you go along and you argue sort of like the big things, like how much of this is even recoverable in the first place? I mean, the judge has said that Colleen, because I've remembered her name now, Colleen Rooney should recover 90% of her costs. The missing 10% is because she also ran a public interest defence, which actually failed, because the judge said, although the story was in the public interest, the way you went around revealing the information wasn't, because you didn't give Rebecca Vardy a chance to reply. So I'm going to knock you back on that. But she's been awarded 90% of her costs. At the original hearing, the judge said, well, you can have £800,000 payable immediately, and the rest can be assessed if not agreed, and they didn't agree. So what they're rowing about? Well, they're rowing about sort of what falls within the remit of reasonable and necessary costs. And you've seen a lot about the sort of hotel bills. But this gets really interesting, though, when we're saying about, you know, they should learn to just walk away from this, because they clearly aren't doing, and I'll come on to that momentarily. But with the hotel costs, they were saying this is all profligate, it's ridiculous spending, they shouldn't have had to do it. But what they're saying is, well, no. Our chap booked into a cheapish hotel, and I say cheap, all my legal aid friends will be going like, what? Because they said it was £250 a night, which is quite reasonable for central London. I mean, legal aid, I think, pays a maximum of £60 a night for a hotel, assuming you can get accommodation costs, which you very rarely can in legal aid anyway, because they always say instruct somebody who lives nearer the court. But what they've said is, well, he booked into a cheap hotel, but it didn't have working Wi-Fi and the shower didn't work, so we managed to get him a deal at the Nobu. Somebody knew somebody, and they managed to get him in there for £250 a night. And yes, he did use the minibar, but he just took out 2 bottles of water. Now, the argument there will be, well, you've got to eat and drink anyway, why should we pay for it? 'Cause it's not like you only eat and drink during court cases. It's a bit like trying to claim things back off the revenue. Like, we can't claim suits, because the argument is, well, you've got to wear clothes anyway. And I think there's a really good counter-argument for that, but I probably would get arrested for it, like that naked Rambler guy. But we can claim for the wigs and the gowns and things like that, because that's not the sort of thing that people generally wear around town. Technically, we're not supposed to. Just to go on a little diversion, because I know you like behind-the-scenes stuff, the rule is that you can only actually wear your sort of barrister togs outside of court if you're moving between the Inns of Court and the Royal Courts of Justice. Otherwise, you have to go into civvy dress. And our shirts actually have detachable collars. So we have the wing collars that you go on and tie your bands, but then we have day collars where you can just put like a regular collar on and a tie. And I quite like those shirts, because if you're away for a long time, more disgusting secrets of the bar, well, it's great because I always buy them with 2 spare collars. And then, you know, even if you're doing like a week-long trial, you can sort of look at it and go, yeah, that'll do. I'll get 2.5 days out of each of these before my neck rubs off on them too much. So they're saying, well, you can't claim that. Now, there's also sort of just general things about when you start these, you put in a cost budget where you predict how much the cost will be, and Rooney's cost budget was £530,000, which scarily enough is about average for a defamation case. However, obviously now the bill is over 1.8 million. So one of the arguments is they shouldn't be allowed to recover further than their cost budget. But the counter argument is, well, this case got a lot more complicated because of Vardy's sort of tampering with the evidence, you know, all the breaches of disclosure, phones going missing, passwords to WhatsApp going missing, hard drives being miraculously wiped. and all that sort of thing. So they're saying it's all down to her. And also, when it comes into assessing costs, you can take into account the conduct of the litigation. And you can say, well, look, but for them, oh, just get rid of somebody calling me there, sorry, Pep. But for the costs, but for your behaviour, these costs would have been a lot lower. So it doesn't behoove you now, love that word, to actually complain about, the fact they've been inflated, because a lot of this was all the arguments trying to get you to actually disclose the material. Also, when it comes to, people are saying, who pays for this? Well, the usual rule on an assessment is it's the paying party pays the costs of the assessment. And these can be hideously expensive in themselves, because you have to instruct cost draftspeople. And that's a sort of specialist type of person where you just dump the file on them and all your attendance notes and all the correspondence. And you go through and you go, prepare a full bill of costs. Break down everything. When you do what we call summary assessment, you just do it in very broad strokes. I spent X number of hours on witness statements at this rate. I spent X number of time talking to my client. This is how long we were in court. It's very broad strokes, and the judge just does it on the day and has a look and goes, yeah, that seems about right. Knock you back a bit on some of that. You didn't need to spend that long doing that letter. You could have got that work done by somebody at a cheaper charge out rate. All that sort of thing. On a detailed assessment, you've got to instruct them to do that. And then you've got this full hearing. And like I said, we've had 3 days already of full hearings, so that's going to be in the tens of thousands of pounds. And then there's going to go for this line-by-line assessment. But it is the paying party who generally has to pay the bill, unless they can knock down the bill so much, like say if they can get it, by like 15% or more, then it arguably shifts and says, well, because it's back to this, winner pays, losers costs. And if you are successful in knocking down a bill quite a lot, then arguably you have won. The mere fact that you get the bill knocked down a little bit, that's just to be expected. I mean, on an assessment, we always warn people, you'd be lucky if you recover 70% of your costs. The other thing people can do is they can actually make offers about, we will accept this. And you can actually do it as a Part 36 offer, one of those formal offers, where the other side has the choice then either to accept that or refuse that, but risk going to the hearing. And then if at the hearing they don't beat the offer, in other words, they are awarded the same or less than they were offered, then they pay the other side's costs. So they would pay the paying party's costs on an indemnity basis, which is, where everything has to be reasonable and necessary, but it's for you. Basically, the starting point is everything is, and it's to you to prove it isn't. So they actually get into the thing of costs of the cost proceedings. So you can see how this massively snowballs and how just ridiculous it all gets. Yeah, I mean that's where we are at the moment. And that quote was from one of Rooney's lawyers, who just said, it was daft of Vardy to sue in the first place, bearing in mind, they argued, she was banked to rights and she was bound to lose. But the saga continues. Oh, the judge also said, OK, it's going off till 2025, but in the interim, pay him another £100,000 just to be getting on with. Because, the argument is you're entitled to those costs, or at least some of those costs, so you shouldn't be kept waiting for them. So she's had to fork out another £100,000. It'll be interesting to see if there were any offers on this. I mean, like I say, my gut feeling is they'll probably get about £1.5 million. So maybe they've made an offer in the background, Part 36 at 1.5 or something like that. But we shall all find out. Also, this is a complete diversion, but I'm going to point into that corner of the screen because I mentioned in the last one about badgers, and I mentioned I had a little clip of a baby badger. So I'm just going to show this. This is from one of my walks during the lockdown where I stumbled across a little baby badger, and I did try to get down and go, oh, come on, but I didn't want to scare him. It was very brave, actually. I think he sniffed around, realised that an annoying vegan was not somebody you were going to be able to tap up for any sort of interesting food. But I hope you enjoyed him and that you found all this vaguely useful, vaguely interesting, vaguely accurate.